Yep, it's being recorded. All right, good morning. Those of you, well, this is my standard speech. Those of you who are just joining, just give us a minute. We're going to let people filter in before we get started. So just bear with us. If you hear silence, it's just whilst we're waiting for attendees to come in. All right, just going to give it maybe 15, 20 more seconds and then we'll get started. Okay, good morning, everyone. I can guarantee that just as I've gone live, my dogs will probably start barking, so I apologize in advance. But welcome. It is Wednesday morning, and today we have our webinar. It's part of a webinar series, and it's about critical legal issues in buying a small business. For those of you that joined a couple of weeks ago, we had just critical legal issues for businesses. And in a couple of weeks, we have critical legal issues coming up in selling a small business. But today we're going to be focusing on buying legal issues when buying small businesses. We have John Murdoch, and he's with Zager Foods, and he's very kindly put together this series of webinars. They will all be available on our YouTube channel, so don't worry if you missed the last one. You can always catch it on YouTube, and this one will be there as well. We are SCORE Monmouth County. We are a mentoring service to small businesses within Monmouth County, but we are a national entity, so there are actually SCORE offices all around the country. We are powered by the SBA, so although we are all volunteers and we all work within the Monmouth County chapter, there are entities all around. We are always looking for volunteers, and we're also always looking for potential customers who may need mentoring. We're a 100% free mentoring service. So if you need help with actual mentoring for your business, or you know anybody who does, feel free to reach out at monmouthscore.com, monmouth.score.org, I should say. I'm going to mute myself because I think my dogs are about to bark, and I'm going to hand over to John, who is going to be managing the presentation. Oh, one quick thing. We welcome questions. We welcome any kind of interaction you want to have. Please put your questions in the Q&A box, and we will get to them at various points in the presentation. Just put them there and we will answer them. As many questions as you want, we'll get to all of them. All right, John, I am going to hand over to you.
Great. Good morning to everybody, and thank you so much for attending the webinar today. It's always an incredible honor when I get a chance to share with people different legal issues, and with the goal is to try to help, especially maybe a person who maybe is not so familiar with the whole process going through buying a business, and just to kind of educate you on critical legal issues that may arise in going forth with buying a business. Just so you know, I've been doing this for probably about 22 years. I've represented all types of purchasers and sellers of small and larger businesses. And again, today I'm trying to comprise what I think are critical issues within an hour's time. And we could have this seminar for all week, but we only have an hour today. So understand not everything is going to be addressed, but hopefully we'll work through the concepts. So as you go through your steps in buying a business, things will not be seeming so daunting, and you'll also be aware of different things to be keeping in mind as you proceed. So, introductory remarks. So this presentation does not address business issues such as business plans, financing, suitability of a business, chances of success, multiple owners, etc. Really, it's going to be select critical legal issues. So this presentation focuses solely on selected critical legal issues to consider when purchasing a business. I put business in quotes because, as we'll get into it in a little bit, you may be looking at an asset purchase, you may be looking at an equity purchase. So again, when I say business, we're talking really either one of those choices. Due to the limited time, not all legal issues would be discussed or discussed in any depth, including but not limited to acquiring only a partial equity interest in a business. That would be a whole separate presentation. The information provided in this presentation is for discussion purposes only and may not be considered legal advice. Please consult with competent legal counsel to discuss your specific legal requirements. So introductory, let's see, trying to get my slides to advance here. Okay, this presentation assumes that there are no conflicts with any contractual obligation, non-competes, etc. The target business is not illegal in any aspect, and consider the concepts presented in critical legal issues, starting your small business, that was just referenced before. And this presentation is for key concepts and not a checklist. So we have selected steps in buying a business. So selected steps, identifying acquisition target, negotiations, due diligence, purchase price, valuation and financing, letter of intent, asset purchase agreement, equity purchases, closing, post-closing. These steps, I put the program together using these steps because fundamentally, this is generally the flow of an acquisition, but they're not necessarily tied to just one particular step. So for example, negotiations may continue even after a purchase agreement is executed. Due diligence is always continuing. So again, these are just selected steps. It's kind of arbitrary in some ways, but this is a way to kind of frame how we approach discussing all the critical legal issues. So first is identifying the acquisition target. So there's various methods for identifying the target acquisition. And we're not going to talk about, again, the business issues, but consider the motives of the, I guess, the means of you receiving information about a potential acquisition. Is this coming from a broker? If it's a broker, the broker is really interested in closing the deal. They get paid when the sale is completed. So they're not necessarily looking out for the best interest of the purchaser. Not even necessarily sometimes the best interest of the seller. They're really, in it, for the percentage. And there's nothing wrong. Brokers do a great service, but understand they're not necessarily your representative. That's really what I'm focusing on. Some brokers are terrible. Some brokers are absolutely fantastic. I do a lot of work in the healthcare area, and I work with some pharmacy brokers who are fantastic, and they're really looking out as much as they can for both sides. But I've seen in other areas where the brokers really do a disservice to everybody. So again, you have to understand how your the target acquisition is basically coming into your awareness. Is it you're contacting the seller directly? Has the seller contacted you? Is this a franchise? Is it other ways that you've been contacted? You want to understand, again, what's going on. What are the reasons for the sale? And this becomes important later as we talk about due diligence. What are the motivations for the seller to sell? Is it that they've reached a certain point and let's say they want to retire, or they say they want to retire? Maybe something happened with the business. Maybe there's a change in that industry. You really want to understand how you came into the knowledge of the acquisition target. Again, just concepts to be aware of. And then also consider whether it's going to be the acquisition of the assets of the business, or it's going to be the equity, if it's a corporation, the stock, or if it's going to be the membership interest in an LLC. And we'll talk about a little bit more as we proceed. So first we go to negotiations. So one of the first points I want to bring up is the question is, what is a contract? So I get a lot of times people think, all right, if it's not written, it's not a contract. Well, that's not necessarily true. If two parties have a discussion and there's a verbal agreement that there's going to be a purchase of let's say the assets of a business. A quick example, someone is selling the assets of an ice cream store, and the prospective purchaser says, all right, I'll buy it for $500,000. All right, great. It's a deal. And there's some other factors that come into it, but you start getting to a point where this may be actually a contract. Now, whether it's enforceable, there's some laws regarding that, but just keep in mind that certain things that you may agree to may become actually a contract. So again, is somebody going to try to enforce a verbal contract? I can't see it really happening. Now, it depends, of course, on the circumstances. But now let's say you change this. Let's say there's emails and there's certain discussions and there's a deposit sent for that ice cream store. All right, now it's starting to really look more like an enforceable contract. So you just have to be aware. Key concept is make sure you're not necessarily agreeing to something unless you really know what you're agreeing to. And it can happen very subtly. And you can kind of get pulled into it in some cases without even realizing. So just be aware of that. So, and we'll talk a little bit more when we get to letters of intent and asset purchase agreements. So next point is need for confidentiality. Now you think, typically, immediately seller definitely wants to have everything to be confidential with the deal. They don't want as much of their information getting out into to the public, but sometimes a purchaser is looking for that confidentiality as well. One is they don't want others maybe to know that they're in negotiations with the seller. And also the buyer may be turning over certain information to the seller in connection with certain financing. Perhaps the buyer is looking to have the seller take back a note in order to close the deal. And maybe they're providing tax returns or other information. So there may be confidentiality on both sides. So really consider that. It's something that how much do you provide under what circumstances? Again, now confidentiality agreement could be contained in a letter of intent. Again, we'll talk about letters of intent, or it could be a confidentiality agreement. It may be contained in another agreement. So understanding whether there's a need for confidentiality, again, definitely the seller wants it. The purchaser really may want it as well. But to understand what you need to have in place before you proceed further. Next point I have is negotiations are a dance. The seller is looking to, as you can imagine, present the business in the best light possible, where a purchaser wants to understand everything about that business, especially all the bad points. Seller may not necessarily provide that information, may not provide the information right away. So as a seller, there's a concern about anybody who approaches and turning over the information, and now maybe that person or entity becomes a competitor, or maybe they are a competitor and now they have all the information. So there's this continuous dance going on. And we'll talk about that a little bit more in due diligence. Put down, be prepared, as a seller will only have limited patience. If you're brand new to buying a business, you really need to make sure you have good advisors, financial advisors, accountant, attorney, insurance advisors, and to really have a good game plan, because the seller is only going to have so much patience, and depends on each seller and the owners. And you have to try to get as much as you can, as quickly as you can, in the most efficient way possible. Put down there, also negotiating good faith. The goodwill of the seller is going to be critical to the buyer, and you don't want to destroy that. I've seen a lot of matters where there was a falling apart between the parties, and the seller, the owners, became vindictive. and tried to do everything, basically trying to live by the terms of the contract, but trying to hurt the buyer every possible way. And then I put in there, consider the psychology of the parties. The seller and the owners have really, at this point, come to the decision that they want to sell, and they may be desperate to sell. They may not be. They may be looking to retire, and especially in the owner's mind, this should be done as quickly as possible. They want it over. And also consider the buyer, very, very excited. And there's kind of like a certain fatigue that sits in with the buyer to can basically be conscientious as far as trying to assert the buyer's rights, to really pursue its due diligence. So again, there's changes that happen over the negotiation process, and even during the time when the asset purchase agreement is signed and the closing occurs. So again, just consider that the parties are coming from different perspectives, and that may be a key factor as you proceed. So next we talk about due diligence. Now, due diligence could be an entire, probably like a full day session, but to hit upon some key factors. Due diligence, a goal is to become completely satisfied with the business, its operations, viability, status, etc. You want to understand good and bad. What are you going to actually be purchasing? Is the business what is being portrayed to be by the seller, by the owner, or is it something else? Now, in due diligence, the concept is what can be independently verified, and that's, for example, going through and taking a look at books and records, inspecting assets, walking around the location, doing inspections, whether you're doing inspections for structural inspections of a location, etc. It's so what can be verified? What can be verified by public record searches? Yes,
John, would you also want to inspect perhaps potential contracts that the seller has with suppliers or with anything like that, contractual obligations that they have, or is that done outside of due diligence?
Yep, great question. So I have a slide in one or two slides forward, kind of like some general concepts, but this absolutely, anything that pertains to the business, anything that is an asset of the business, and one of the assets would be the contracts that the business has. Now, we go back to what I said before about advance. Depending upon the seller, their status, their interest, some of these items may be readily provided. I've had in some industries, by the time I get pulled in to prepare a contract, my client, the purchaser, has seen everything and they're fully comfortable. A lot of times, and if I'm representing the seller, it's you give enough to get.
I'm not sure if you can hear me, John, but you froze.
Oh, I'm sorry. No, I didn't know. Let me know if that sounds better. Okay. Well, hopefully that's better.
That's better.
Okay. Okay, here we go. So yeah, you're going to want to review all assets, all aspects of the business, and trying to verify independently anything pertaining to business, the hard assets as much as you can, some of the intangible assets, which comes up through various contracts, etc. There's certain public record searches that can be done. So you're working through all those searches, and that's where you really you have your team basically assembled to be able to give you kind of advice on what to be looking for, and some of that advice may be very industry specific. Some things that maybe an insurance advisor, attorney, or accountant might not understand, where those advisors would really understand like core concepts in these types of arrangements. And I put down that buyer, seller, and owners have some similar but also different goals. A seller, of course, is trying to portray the business in the best light they can. where the buyer really wants to know what are all, where are the skeletons, where are the problems, how is this going to work out if the acquisition is successful. So I mentioned assembling your team. We talked about briefly before confidentiality considerations. Usually, again, that could be either a letter of intent, a confidentiality agreement, but again, as you're going through the due diligence, you think of the buyer's due diligence into the seller's business. But again, sometimes the seller is conducting due diligence in connection with the buyer, especially if there's going to be financing potentially offered by the seller. The seller is going to take back a promissory note, for example. They want to understand if the buyer is going to reasonably be expected to pay back the loan or other whatever other contingencies or qualifications that buyer may need to basically take over the business. So again, to think about those how important confidentiality becomes for both sides in the due diligence. As far as scope, this is a dance. I've mentioned it before. The seller may only want to reveal so much information at certain points. The seller may say, all right, we'll reveal so much now, maybe before there's a letter of intent, or maybe after a letter of intent is signed, and maybe you only get additional information once the asset purchase agreement is signed. I've actually had situations where there was certain information that was so confidential, it was only revealed at closing because the seller was so worried if the deal didn't work out, even if they had a completed and signed asset purchase agreement, the deal might not go through. And they were so concerned about revealing their clients that what we actually did in the contract is we put in provisions that said, all right, we have certain types of clients here, they're basically their characteristics, and these will be identified by name at the closing. So we've actually done things like that. So again, it depends on how sensitive the information is. But again, it's always this dance because the deal may not go through. It may not go through, and that may hurt the buyer, it may hurt the seller. So consider how much information is given when.
John, there's a question as well from Joe. Hey, Joe. Is there an obligation on the part of the seller to provide certain and specific information? For example, from a financial perspective, does the seller have to provide their financial statements and tax returns?
Great question. Now, typically when I'm representing a buyer for a small business, I usually put a very broad provision in the due diligence portion of the asset purchase agreement, saying that the seller will cooperate with all of the buyer's reasonable requests for due diligence, but the buyer then has a certain period of time in order to determine whether they want to go forward with the deal or not. Usually be anywhere 20 days, 30 days, 45 days, whatever, it depends on industries. And if the seller doesn't cooperate, let's say the seller is holding back certain information, the buyer can just walk away. Sometimes you can put together a due diligence list as part of that and say, all right, we want all these documents. Tell us if you have them or you don't. And if there's any concern on the buyer's perspective that the seller is not fully cooperating, being a little cagey, again, we'd like to have in an asset purchase agreement, the purchaser can walk away and basically get any deposit monies back. So yeah, so there's two ways. One is you could say, all right, provide us this specific list. Or that's probably better done with a broad provision where the buyer can walk away if they're not satisfied, and if they're not satisfied if the seller is not cooperating with everything they asked for, especially follow-up requests.
Great, thank you.
My pleasure. So when does due diligence begin and end? So it can be before or after a letter of intent is executed. It can be before or after a contract is executed. The earlier, the better for the purchaser. For the seller, they want to give it usually just enough to get the purchaser to sign the agreement. So there's no hard and fast rules. Again, I've seen some deals where I'm brought in and my client, the purchaser, has seen everything and is completely good and said, all right, just draft up the contract. We want to close in a couple of weeks. But usually that's not the case. And if I'm representing the seller, I want them to hold back until we have a fully executed purchase agreement, because now you have, typically you have a deposit and you really have certain additional protections for the seller. So again, there's no hard and fast rule. And considering also with the due diligence, what is needed to complete the purchase and operate the business. Again, as you're not only thinking about due diligence with the seller, you're also thinking about maybe outside third parties. Are there governmental approvals? What do you need to investigate? Are there certain other contracts? We talked just briefly before about taking a look at the seller's contracts, but are there other contracts that are going to be needed? Are there going to be new contracts that are going to be needed to replace the contracts the seller has? And then other requirements depending upon the specific business and the industry. So I put selected due diligence items. Again, not a comprehensive checklist. That would be pages and pages, but to kind of give you a sense of what you're kind of looking for as you're going through due diligence. You're looking through all the financial records. And this is something critical I mentioned before about assembling your team. You're getting those financial records. You're talking with your accountant. You're talking with another financial advisor. You're talking potentially if you're working with a bank. The bank is going to want to see all those records. So you may get initial records, but there may be follow-up needs. Organizational paperwork, certificate of good standing for the selling entity, the organizational charts, employee list, the customer, client, patient information, as well as the information for the suppliers, vendors, the contracts and leases, this seller's obligations, insurance, litigation, governmental investigations, violations, etc. So there's a lot of different items that go into a due diligence request. Again, this is just for concept purposes today for the webinar, and it's not a detailed list because each list becomes very specific to the type of business. For example, certain due diligence items that we're looking for if you're looking to purchase a physician practice is going to look a lot different than you're going to buy a pharmacy or you're going to buy let's say a bar or restaurant that has a liquor license. So the due diligence list will be modified depending upon the businesses. But again, this is really for concept purposes. So now we get into purchase price, valuation, and financing. Again, this is more from legal concepts. This is not for business issues. So first is a purchase price acceptable? Now, a person who has plenty of money may be willing to pay what potentially is over the market value for a business. It's not so much that it is the purchase price acceptable? Does it make sense from your particular situation? And was there evaluation completed? Do you understand what you're really purchasing? Do you need evaluation? And we go back for if there's a lender involved. A lender will only lend money if they believe that the value is going to be appropriate. And of course, the loan to the value ratio, things like that. Again, that's just, do you need to have some verification and justification that what you're paying is acceptable? Is there some type of determination of value needed by law? In healthcare, you may need to have a valuation to determine fair market value for certain acquisitions between referring entities. So again, just a concept to be aware of. Again, you're paying cash, you're happy with the price, that may be fine. But are there other considerations you need to make? And this goes back, tied in with the due diligence. As you're going through and examining, does anything come up that renders a previously acceptable purchase price to not so acceptable? And do you need to renegotiate? I mentioned before in the due diligence provisions in my agreements, I have a certain period of time they can do their due diligence, and they can my client, the buyer, can terminate in their sole discretion. That's great if you can get that. That allows a situation where something is determined that really affects the purchase price. The buyer can say, listen, I'm going to terminate the agreement. However, if you're going to reduce it to a more acceptable level, the purchase price, I will continue on with the deal. So sometimes you really don't understand if the full value of an entity until you kind of go through that due diligence. And then there may be other things that change the value of the business between the signing of the contract and the closing. So, but next point is, will the purchase be financed, seller, lender, investors? this is more, again, not the business issues, but if the purchase is going to be financed by the seller, all right, there's going to be different terms that need to be considered as part of the purchase agreement. If it's the lender, there's going to be a lot of lender requirements in order to get that loan. So working with the seller to get to be able to satisfy those requirements is going to be critical. And then I just mentioned investors. Sometimes some businesses will basically bring in investors, and there's a whole separate set of other legal issues with that. But understand that if you're bringing these investors, what are the other criteria that need to be satisfied, whether it's legal requirements, contractual requirements, etc. And then terms of financing, I put in benefits of seller financing, is that if something goes wrong down the road, and you've had a seller that basically allowed you the seller issued basically a promissory note, basically a loan from the seller in order to close, whether completely or partially on the purchase of business. It's absolutely fantastic, because if something develops later on that turns out that was something that's really the seller's obligation, you basically have some monies to draw upon. You have an obligation to the seller, but now you have, there's an obligation basically both ways. And now you have a source of funds basically to address it. So it's a great thing to have from the buyer. I hate it as a seller, but sometimes it's necessary.
Is that what you would kind of call an earn-out or something similar to that?
Great question. A little bit different. So with an earn-out, and that's that may be something that can a factor into a purchase price, in that maybe you don't give all the money to the seller at the closing, but some of the purchase price is basically an earn-out contingent upon the operations of the business after the closing. When you see private equity, their acquisitions almost always have it. I don't think I've ever seen it without an earn-out, and they're basically they're transferring a lot of the risk in the acquisition onto the seller, saying, well, if this is really as good as you have said it is, then great, you'll get some of the purchase price over a period of 6 months, a year, 18 months, whatever, provided that the business hits certain types of benchmarks. So now, but with a promissory note by a seller, that would actually do is, let's say a seller selling the business for $500,000, and they're taking back a promissory note for $400,000. Again, $100,000 at the closing, $400,000 is paid over 10 years by the buyer. And it turns out that a liability of the seller before the closing arises, and the buyer gets stuck with it. Well, at least they know they can offset that promissory note and say, well, all right, seller, you're supposed to take care of this, and since you didn't, I'm going to deduct from this promissory note certain payments until basically I'm made whole. So it's absolutely fantastic. There's an alternative way we'll touch upon later, is you can also have an escrow agreement held for a certain period of time, where if any liabilities of the seller come up, that the buyer can draw upon those monies. And then at the end of a certain period of time, whatever is not applied to obligations of the seller, then that money gets turned over to the seller, and that's after closing.
Great, thank you.
Oh, my pleasure. All right. Okay, so we're going to go to letter of intent. So I've basically mentioned briefly concept of a letter of intent, but a letter of intent not required. Some attorneys hate letters of intent. Some love it. For me, it depends upon the circumstances, but there's key points in the letter of intent. Is purchase price. If there's going to be seller financing, what are the assets, liabilities that are going to be picked up by the purchaser? Is there going to be a non-compete, non-solicitation agreement, confidentiality provisions? This is usually where you'll get the confidentiality protections, is usually in a letter of intent. If there's no letter of intent, we'd like to have a confidentiality agreement. No shop clause that, all right, if the buyer and seller enter into a letter of intent, the seller isn't meanwhile going out trying to sell this to a prospective other party. So now the buyer may be unknowingly in competition with another prospective purchaser. Usually there's a period of time for the parties to negotiate a binding and what they call a definitive purchase agreement. Usually you have 20 days, 30 days. So if the definitive purchase agreement is not executed, the letter of intent usually expires, except for certain provisions like confidentiality usually continues in full force. Due diligence is often addressed in a letter of intent, especially private equity. Typically, their letters of intent include very clear terms for their due diligence, and there's also closing contingencies and other points agreed to by the parties. A note I put in: letters of intent may be binding, may be non-binding, or binding only for certain terms. So I get a lot of people saying, well, I signed a letter of intent, so it's not binding. So, well, it depends on what the letter of intent says. So you always have to have it reviewed. Typically, provisions that are binding in a letter of intent are confidentiality, no shop provisions for a certain period of time, and maybe some other provisions. But there are sometimes letters of intent that you basically agreed to purchase the assets or the equity of a business, but it's just all the other terms have to be worked out. But you're now required to basically agree to reasonable terms. So you always have to be very careful. A letter of intent may be completely binding upon the parties. Okay, so we'll go into an asset purchase agreement. So assuming that you've gotten either it's a letter of intent or it was decided that no letter of intent would be entered into, and assuming that an asset purchase has been decided, and we'll talk about the difference between that and equity purchase in a little bit. But let me pause here. Probably 95% of small businesses that I've seen, the purchase is going to be by an asset purchase agreement and not basically an equity acquisition. The theory is that in buying the assets, you're not picking up the liabilities of the seller. It's not completely clear, and a lot goes into the contract. And you still, as a buyer, may have issues with sellers' creditors, other contractual parties of the seller. So it's not absolute that you're not picking up the liabilities of the seller, but it's a very important step. So basically, what you're doing, you made the decision to purchase the assets. You purchase the assets, and then specifically say we're not picking up any liabilities of the seller unless you agree to in writing. And now you basically start a brand new business. So you're not buying the seller, the entity. You're basically starting a brand new business, and in buying certain assets, you may be picking up the name of the seller. But again, the theory is, all right, let's separate ourselves from the selling entity. We're a brand new entity. Yeah, it may be we have the assets of the old entity, but that's a different entity. The seller's problems are not our problems. They're the seller's problems. If you have an issue, go after the seller. But again, it's not absolute, and you still may be stuck with certain problems because you acquired the assets. But that's the general concepts. And there's reasons for an equity purchase, which we'll talk about. So just, I guess, first point, who prepares the asset purchase agreement? The best practice is for the buyer's attorney to prepare the asset purchase agreement. The seller wants their money. They want out. In a very simplistic concept, if there's going to be an earn out, they want those monies as well. But the buyer really wants a lot more protections in the agreement, usually, not always, than the seller wants. So typically, the buyer's attorney prepares the agreement. Sometimes there's a broker prepared agreement. But it's usually not always fully appropriate to a buyer. Again, some broker agreements are great, but I've never seen one that didn't have to be modified. Sometimes the seller's attorney will prepare the agreement, but it's not likely to be sufficient for the buyer, and it's typically going to leave out critical items. And the worst situation is if the parties go about preparing the document themselves. They have something from maybe another deal that hasn't been tailored. They find, even worse, they find something on the internet. It's almost, if there's any type of sophistication to the business at all. I mean, I'm talking other than buying maybe you have a lawn mowing business where it's a push lawnmower, and the parties enter into agreement on their own. But even then, there could be issues. But I mean, anything of sophistication, you have to have good counsel in walking you through that agreement.
John, we have a quick question, just
Sure.
going back to just actually going back to letter of intent. it's non-binding always for real estate, but might they be binding for other businesses? And I think you may have addressed that, but I just wanted to,
Absolutely.
the question came up, so I just wanted to.
Yeah, a great question. And I'll say this, the letters of intent are supposed to be non-binding. And even the name, letter of intent, implies that it's non-binding. But I've actually seen, I've seen letters of intent that included real estate, and it wasn't real estate on its own, but included real estate that when you actually read it, it really was a binding agreement. So again, you always have to be very careful. Typically, the way I address that is I put certain language at the end. I have some standard language, and that provides that if a definitive purchase agreement is not reached by the parties within 20 days, 30 days, whatever the time period they agreed to, then the letter of intent becomes null and void, except for maybe certain provisions like confidentiality would continue, things like that. But you want to have it clear that if you need to, either party can terminate, or basically you can run down the clock. And if there's no definitive purchase agreement, it's not binding other than selected items or provisions like confidentiality. But yeah, you always have to be very careful. It's pretty rare, but I've seen a handful in 22 years that actually, when you read it, were binding. All right, so selected components of an asset purchase agreement, we'll go through these kind of quickly in the next slides, is identifying sellers and owners, purchase price and terms, assets to be purchased, liabilities to be assumed, if any, contingencies, representations and warranties, indemnification, restrictive covenants, non-competes, non-solicitation, miscellaneous provisions, and other provisions as applicable. So first, identifying the sellers and owners. And this goes back with the due diligence. Does the seller have the authority to sell all the assets? Is there other companies that may be owning some of the assets that you're looking to purchase? Are some of the assets leased? These are all things that are identified through due diligence, and they also get identified in the contract. So, for example, we will put together a list of assets, and very specifically identifying all the key assets. And if let's say, for example, a seller says, oh yeah, we have the copy machine as ours, and they list it as an asset. It turns out to be a lease. That's an issue. But identifying all the assets, so this way you have certainty when you go to close that you understand what you're buying. Or maybe there's certain assets you're going to have to lease. That's fine as long as they're identified, and then you understand what the terms of the contracts are in connection with those leases. Now, are all the owners of the sellers identified and signing the contract? And we'll talk about indemnification later. So realize that you have this selling entity that after a certain point is going to disappear. It's going to be dissolved. And if you have any issues after the closing, who do you go after? It's a lot easier if you have the individual owners of the seller joining in on that contract, and especially for indemnification. We'll talk about that. All right, so purchase price and terms, again, all set forth in the contract. What is the purchase price? How is it paid? Is there a deposit? Is there a lump sum at closing? Is it financed? Is there certain, scheduled payments after closing? If it's seller financing, what are the terms? So everything becomes spelled out in the agreement. So is there security for the financing, especially if it's whether it's the seller and maybe taking a security agreement. Again, we won't go into detail today. Or is there going to be a third-party lender, a bank that's giving the financing? What are the key terms that need to be addressed in the contract? And it was I have my earn-out section here, but we already talked about that, which is great. And then we talked about escrows for indemnification events or other reasons. Again, after the closing, for an escrow, it's great to have it as a buyer, because if something happens and it was an obligation of the seller that the buyer's getting stuck with, maybe you have some monies to draw upon. And so escrows are fantastic. Sellers hate them because the concern is the buyer's going to come up with these crazy, stupid reasons and hold back paying the seller the full amount of the escrow. So assets to be purchased, just selected assets. And then again, this is for concept purposes only. Each deal is a little bit different, but you think about the hard assets, the furniture, the fixtures, the equipment, vehicles, whatever it may be. And all these assets you want to list as specifically as possible. Better for the buyer and better for potential disputes at the closing. So, and I have some clients and, that say, listen, it's just whatever is there. And I'll tell them, so, all right, the day of the closing, if what you think is was supposed to be there is not there, you have a hard time disputing it. It's great when you list out on attachments, all right, here's the specific furniture. You don't have to go crazy. It depends on the types of assets, but key items, certain fixtures, certain equipment. If you're talking about computers, serial numbers, etc. So the more detailed, the better it is, and basically you have kind of a closing checklist to verify everything. The records of the seller, the inventory, the trade name. So even though let's say it's an asset purchase, and you're opening up a brand new business to acquire the assets, you can still buy the trade name. So if it's John's ice cream company that I'm purchasing, and I set up a brand new company, I could still then purchase the rights to that name. So that's an asset. Even though my company may be XYZ LLC, I can do business as John's ice cream store. So that all these things need to be understood and listed as specifically as possible in the agreement, so you understand what you're acquiring at the closing. So we have software, we have goodwill, intellectual property, and any other assets as appropriate for the deal. Again, not a comprehensive checklist, more for concept purposes. The key thing is with the purchase price is making sure that it's allocated and everybody's on the same page. So if we go back to the ice cream store, if the seller is going to report to the IRS that $200,000 was equipment, that the buyer is reporting the same number to the IRS, and they're both on board. So just be aware, and this is typically something you work with your accountant on, but understand that there's there's other entities involved with this acquisition, and one consideration is making sure everybody's on the same page as far as the allocation of the purchase price. And typically that will be addressed in the agreement, but it's important for tax reasons, and make sure there's no disagreements between the parties when they report to the IRS, because if there are disagreements, now you've got some potentially very big problems. Now, typically, when you're acquiring the assets of business, you're looking to acquire, substantially all the assets, but typically the seller is not going to be providing or selling all the assets. So typically they're holding back on cash, accounts receivable, not necessarily the same with equity, private equity deals. They're usually looking for that. But typically small businesses, the seller's holding the cash, they keep the accounts receivable up to the closing, their company books and records. I mean, their corporate kit, with their minutes, their resolutions, typically they don't transfer those. There's contracts that the buyer is not expressly assuming, and maybe other assets. There may be artwork that one of the owners had in the location that's not part of the sale. So all these things get defined in the agreement. The key thing is that there's no disagreements, there's no surprises, and you don't have one party assuming something and the other side assuming something else. So seller's liabilities, again, with an asset purchase, you're not looking to assume any seller's liabilities unless there's a really good reason. So seller's liabilities obligations, you may need to pick up the lease. You may get a new lease. There may be leases for equipment. There may be other obligations and liabilities, but the key point is to be very clear about what's picked up and what's not. So that gets detailed in the agreement. Again, a critical legal issue. And we go back to we talked about before, is that you're trying not to pick up any liabilities of the seller unless they're understood and acceptable and they're clearly spelled out, because you want those spelled out, because if any other liability comes up that affects you after the closing, you want to be able to basically defend against that, and then also turn to the seller and say, listen, this is your obligation. We never agreed to this. So again, spelling that out is critical. There's past conduct of the seller. Again, we'll talk about that with indemnification, and then maybe other liabilities as appropriate depending upon the business. But the concept is to understand what you're picking up as far as seller's liabilities, if anything, and to have it really detailed in the agreement. Okay, there's contingencies to close. So kind of building upon what we were talking about before, there's going to be various contingencies of clause. So if a person's going to a lender for a loan, we're going to put in there, well, if the person doesn't get the loan, they're not going to be approved. That they're completed their due diligence, it's satisfactory. They get any governmental approvals they need, or the buyer doesn't have to close. Any other third-party approvals, whether it's a landlord, it's a franchisor, whatever. So these are all contingencies that the buyer is looking to have in the agreement, providing that if any of these things are not satisfied, the buyer doesn't have to go through and come up and to the day of closing and complete the transactions. So these things become critical. Again, very, some selected contingencies, not a comprehensive checklist, but different things that must be carefully considered. You want that out if things don't go well, if things don't proceed the way are really required from the buyer's perspective to go to the closing. You need a way to be able to get out of the deal and then walk away. And I'm just going to move a little quickly because I know we're running out of time. I wish we could have the whole day, and I'd love to spend it with everybody.
Maybe we could do an in-person webinar.
Yes,
or an in-person seminar, I meant.
That would be great. Yeah, because I get so excited. I want to talk about every single issue. Just quickly, you may see in a contract, you see representations and warranties. These become critical. You have to understand that mentioning due diligence, there's certain items that you can verify on your own. There's certain things you can't. So if an owner is aware that there's a violation of the law, but there's nothing in writing somewhere that you can verify, there's nothing, on a governmental website regarding this, you don't know. So you rely upon all the representations and warranties of the seller to basically address items as much as you can that you can identify and verify, but also things that you might not be able to know. The seller might be aware that someone verbally threatened to sue them. There's no document necessarily out there to verify that. And even if there was, you might not be able to find it. So hitting these representations and warranties are critical. Not that they conclusively establish that these items are true, but you're trying to draw out any potential issues. And then they become critical when we talk about indemnification. Okay, again, and you'll be able to get a copy of the slides. You'll be able to see some of these points, again, for concept purposes only. And again, additional representations and warranties, again, some concepts. So just a concept, and next one is covenants before and after the closing. Typically, there's obligations of the parties to do certain things before the closing and after. You have maybe the obligation of the seller to operate the business in its normal course, not to run the business in the ground, not to pull out all the inventory, not to lose all the employees. There may be certain obligations to execute and deliver certain contracts. There may be certain payment obligations, whether to the seller, to other parties, performance of any duties. It could be certain duties of seller or owners to provide training before and or after the closing, maybe for one or more owners to stay on as an advisor. So again, to think about what's going to be needed outside of just going to the closing, what are the obligations between the parties before and after the closing to make this really viable for the purchaser. So we kind of touched upon this before, but consider indemnification considerations. So the goal in buying the assets of the business, again, is to try to limit exposure to the seller's liabilities. But again, I mentioned it's not absolute. So one of the things you put into a purchase agreement is indemnification obligations for both sides. You're looking really from the buyer's perspective. You want the seller to say, hey, if we breached any of seller's obligations under the agreement, if there's any third-party claims against the seller, if there's any claims concerning the business of the seller, before the closing, if we breached any representations and warranties, basically lied about something, then we should indemnify you, buyer. So if, let's say, there was a claim for the seller's business and happened before the closing, and it's not something the buyer took on, well, if it arises and the buyer gets stuck with it, even if they don't have to pay it, but they have to defend against it, we want the seller to indemnify the buyer for those costs and those efforts. So this gets back into what we're talking about in escrow. It gets back into the, if you have a promissory note, it's absolutely fantastic because you can offset the promissory note. And I also mentioned that consider the value of indemnification of a seller that is a corporation or limited liability company. That entity is not going to be around forever. So what's absolutely great to have is have the owners joining in the contract and joining in on the indemnification. They're joining in on the representations and warranties. So if a representation and warranty proves to be untrue, it's not only just a selling entity, which may be dissolved at a certain point, but it was the individual owner as well. You may have a claim against them, and you have the indemnification provisions. It may be a claim against the seller's business, and it arises 2 years after the closing. The selling entity may be dissolved. You may now be going after the owners. And so that becomes critical in trying to protect yourself as much as possible. Of course, when I'm on the seller side, I don't want those owners to join in on the agreement. So, we're running out of time. So we have, just to consider, you have restrictive covenants, non-competes, non-solicitation. They're absolutely critical. When you're buying the business, you don't want the selling entity and or the owners to basically go out, steal your employees, steal all your customers, basically take your vendors, and open up and compete with you. So this becomes very critical on how you detail it. So if you're dealing with, let's say, a pizza restaurant in an urban area, you don't really care if the sellers maybe go 50 miles away. Who really cares? They're not going to be stealing from your business. But now if you're a business that's, let's say, developing and selling software, doesn't matter where they go in the world. So these things become critical, but it's about protecting what you've understood to be your acquisition. Just consider potential additional provisions depending upon the business. You may have concerns in the contract if there's a liquor license involved, if there's Department of Health licenses, if there's certain provisions for pharmacy, ambulatory surgery center, daycare center, whatever. There may be very specific provisions in addition to the general concepts that need to go into that contract in order to protect what you're attempting to acquire. There may be services of owners, again, maybe training before or after the closing. There may be a transitional period where you get to have access to the seller and maybe some items that you didn't pick up of the seller, like let's say their bank accounts or certain businesses where after the closing, you don't have certain approvals where all your receipts still go into the seller's bank account. You need access to those. So again, understanding the business may require some nuances in the agreement. I'm just going to go through this because I know we're almost out of time, but the miscellaneous provisions in a contract become absolutely critical and need to be understood. All right, we'll touch upon equity purchases. Now, I mentioned briefly some of the reasons for acquiring the assets in a business. There may be times where an equity purchase is necessary. So there's certain times where it's unreasonable to buy the assets of a business. So imagine a publicly traded company. How could you possibly go about listing all the assets? It'd just be insane. You just buy, you buy stock in the entity. Insurance companies, you can't just buy the assets of an insurance company and start up a new insurance company. There's a lot of requirements in order to obtain licensure. So there's different reasons for acquiring the equity in an entity versus buying the assets, but there's a lot more risk. Because you're acquiring the entity, good or bad, with the assets, but all the liabilities. And again, you can contractually try to limit those, but still you bought the entity. Now, I usually tell clients that you consider it like a two-layered acquisition because you're purchasing the equity entity, but you're still considered concerned with all the aspects of an asset purchase agreement. So typically, a lot of those same items, as far as addressing all the assets, the liabilities, going through all those things, those are definitely addressed in an equity purchase agreement, but it becomes much more complicated. And there's, concerns you're buying the equity, but you want to make sure that the entity that you're obtaining, through the purchase of the equity really has all the assets and what liabilities, et cetera. So it's much more, it's riskier from a legal perspective, a little more complicated, but sometimes it's what's needed to do the deal. So not wrong, but it's usually much riskier. All right, we'll just go to closing concepts. So ownership is transferred at the closing. It may have a different effective date, but typically once you get to the point of the closing, the transactions are being completed, title of the assets are being transferred, or it could be the equity. The purchase price is paid, whatever portion is paid at the closing. There may be a payout over time. There's closing documents that are executed, and appropriate post-closing actions are taken, whether it's licensure filings, applications, notices, tax filings, etc. So just again, to give a feel for what's executed at closing, because I get people asking, well, when do I sign, when do I get the bill of sale, etc. So it's generally, delivered at the closing. You get resolutions from the entities that they consent to the transactions. You get a closing statement setting forth what's being exchanged financially, whether it's a certain amount in cash, promissory notes, whatever, a bill of sale. So transferring the ownership of the assets. There's leases and other contracts. There's non-compete agreements. There's employment agreements, consultation agreements, and any other agreements as appropriate for the transaction. But again, to give you a feel of when these documents are typically exchanged. We go into post-closing. So consider what the post-closing obligations of the parties, contract with the seller, the owners, any of the liabilities that are assumed by the buyer. And so let's say they picked up a lease, they've picked up contracts with suppliers, maybe there's employment agreements with employees, etc. What governmental filings and approvals are needed, third-party approvals, third-party agreements, and then other actions as really dependent upon the deal. So that's it. I know I've tried to put in so much into a short period of time, and really my goal was to for you to be kind of comfortable when you hear different terms. You kind of understand where these things kind of fall into place and some of the significance of some of these items. Again, we could go for hours and hours about these issues, but my real goal was to empower attendees to be in a good position to understand, all right, I understand some concepts when I'm talking to my advisors. Well, what about this concept? What about that concept? How do I need to go about protecting myself and protecting my my new business? And it's, as always, it's an incredible honor. I don't know if there's any questions that I can answer.
There aren't actually. There's no questions right now, because I think, John, again, it's like completely thorough and detailed presentation, and we really, really appreciate it, because I know buying a business and I know selling a business can be very, very daunting. It's great because you're excited and you have the ideas and you have the drive and the passion to do it, but there's a lot of detail that goes with that. So trying to put that boil that down into an hour is definitely very challenging, but you did a great job. So thank you. I appreciate that.
My absolute pleasure. Anybody wants to reach out, they have a quick question or something, follow-up question, I'm happy to answer.
Wonderful, thank you. So for those of you who saw the last webinar, or hopefully you'll join us on the next one, we're going to be talking about selling a business and what's the top line sort of level of what's involved with that. So John's going to be presenting that again, and we have a couple of other webinars scheduled as well, which my memory doesn't serve with what they are right now, but if you check out monmouth.score.org, you'll see them on there. This webinar will be on our YouTube channel, and excuse the noise in the background. We'll also, anybody who wants a copy of the slides, please let me know and we can get them out to you. John, again, thank you so much. Super appreciate it. And we'll see everybody next time.
Great. Thank you to everyone again.
Thanks, John. Bye-bye.